Hi there everyone, my name's Olivia Atkinson, in case you didn't know. So I'm writing a petition against our local council, the Berwick Council, because we've been experiencing abuse. And I'd call it abuse because it's been harassment, prejudice, discrimination, and manipulations of law. So a quick backstory on that. We moved onto our block of land in Finley in mid-December in a bus conversion. Pretty much straight away we were told over the phone that we weren't allowed to do that, and then after the Christmas holidays we got a visit in person and we were told that we weren't allowed to live on our block in a bus conversion. And I asked them why, and they said you just can't do that. Anyway, they called us to a meeting in April, and that meeting was to clarify why we were living there or our circumstances, and then to advise the occupants that council approval was required before permission could be granted for the family to live in a bus on this site, and to advise us that the council officers had obligations per the following: Local Government Act 1993, Local Government Manufactured Homes, Estates, Caravan Parks, Camping Grounds and Movable Dwellings, Regulation 2021, New South Wales, Subdivision 3, and the Protection of the Environment Act, Regulation Waste, Blackwater and Greywater. So basically what happened is we put 2 applications for a sewage line into the council, and they rejected it both times without any real reason. And their reason is really we live in a bus conversion, so they don't want to, which I strongly disagree with, but it's basically a system like a caravan or RV. We have a sewage tank and we go and dump it at an official dump site at the Finley Showgrounds. Anyway, Subdivision 3 is where it gets really interesting, which I'll just read out. Sorry, I have to find it. So, Subdivision 3, installation of movable dwelling on land other than land in a caravan park or camping ground, installation of which approval not required. The approval of the council is not required for installation of the following. I'll just skip down to where it applies: a movable dwelling or associated structure on land to accommodate a displaced person if the movable dwelling or associated structure is maintained in a safe and healthy condition and removed within 2 years after installation. So I would consider ourselves displaced because 1, we're in a national housing crisis, and 2, there are no rentals available in Finley, and when there are, there's quite a few people going for them, and it's very hard to get a rental. So we did something to suit us and our circumstances, and that was living on our own property in a bus conversion. And for people that don't know what a bus conversion is, it's basically a tiny house or an apartment on wheels. That's it. We have everything that's in a normal standard home, it's just shrunken down a little bit. So moving on from that, after we had our meeting, they gave us 28 days to show us the laws that told us that we could live there, because even though they gave us Subdivision 3 of the Local Government Act 1993, they just completely blatantly ignored the fact that it said that we were allowed to be there without approval and that we could be there for 2 years. And there are quite a lot of other laws allowing us to live on our property, and there are no laws prohibiting people from living on their property while they're building. So we have our house plans in, so we can live there technically for as long as we want while we're building our house. So anyway, moving on from that, they sent us a draft order on the 10th of May. And basically it was because we didn't get council approval. Even though we didn't need council approval, they still sent us a draft order. So we decided to put a development application for our bus anyway, even though, again, you do not need one, which they, of course, rejected. And literally the day after they rejected it, so the 20th of June, they sent us their official order. So their official order, and this is where it gets crazy in my opinion. So their official order is, the reasons for the order are: continued occupancy of the premise constitutes a life-threatening hazard to you and any other person occupying the premise, and the manner of disposal of waste as a consequence of your occupancy is a threat to the public health and safety. So that's extreme in my opinion. And then another reason going on, or it's kind of the same, just rehashed, that you have stored human waste on the premises without approval, and that waste is likely to cause threat to public health. And then they summed it all up by basically saying these are the two issues: you have installed a movable dwelling at the premises without approval, and you have installed a human waste storage facility at the premises without approval. So basically their issue is that we didn't get approval, so they have a gripe with us. And it turned from a waste tank to a human waste storage facility. So now we have a human waste storage facility on our property, apparently, according to the Shire. But this is where they got sneaky. This is where, in my opinion, they manipulated the law quite a lot. So because they completely disregarded subdivision 3 but to us, but they thought they would use it in this instance because down the bottom, again, I'll just read it out: a movable dwelling or associated structure on the land to accommodate a displaced person if the movable dwelling or associated structure is maintained in a safe and healthy condition and removed within 2 years after its installation. So this is where they've gone back and gone, hey, let's just manipulate the laws and say that it's unsafe and not healthy, and then we can force them off their own property because we deem that it's not safe and healthy conditions, which is a load of BS. Basically, I won't say it, but it's a load of BS, and they know it, and I'm calling their bluff. And this is part of the reason I'm doing this petition, is I don't think local councils can just misuse and abuse laws and basically be legalized bullies. I think it's not fair. And if you think this is pretty crazy, they have literally sent us, I've just turned it over so you can't see the street address. They've literally sent us a $3,000 bill basically for not complying. So on it, it says the short title of offence. This is the reason: carried out development forbidden on land. Any other case individual from the Berrigan Shire. So the craziness continues. We've been fined $3,000, which I'm not paying, so that's just not happening. I think what they're doing is insane. It's crazy, and it's an abuse of the laws. It's manipulation of the laws. It's just wrong. To me, that it's wrong. I don't know how they can get away with that. They feel like they can because no one really stands up to them, and they have deep pockets, so legally it's super expensive to go up against them. So this is part of the reason I'm doing this petition and doing a video, is to bring public awareness, is to call them out publicly so that everybody can see what they're doing, and they have to be held accountable for it. They have to realize that these actions that they're doing are not okay, are not acceptable, and that it's unfair to young families, it's unfair to members of the community, and it's just plain wrong. So I hope that you can sign this petition, or you feel like you want to, and thank you for listening. I really appreciate it. And that's all I have to say for now. I'll keep you updated on our crazy story. I'm going to be sharing this on lots of social media platforms, and yeah, I'll keep you posted. Thank you for listening.